Well, hello there. My name is Austin Nowakowski, and I am the owner of Nowakowski Legal, PLLC. We are your Washington based inheritance lawyers. We assist our clients with probate administration, estate planning, and if necessary, estate litigation. In today's episode, what I would like to talk about is the steps leading up to probate. We're not necessarily going to speak about the probate process itself just yet, but what I would like to talk about is right when you lose a loved one, what steps should you be taking to A, determine if you should be pursuing a probate, and B, to figure out what you need to do to proceed with that probate. So with that being said, let's just jump into it. So this video is actually going to be a relatively brief video, and that's because it's fairly simple to prepare for the probate. It's nothing that's going to be overly complicated. There's basically 5 things that I would really suggest doing. First and foremost, obviously, you're going to want to bury the deceased or cremate the deceased. You're going to want to basically deal with their remains. Secondly, you're going to want to determine whether or not they had a will, and if they do have a will, you're going to want to locate it. Third, you're going to want to make sure that their home or their property is secure. Simply make sure that the doors are locked and that nobody's going to be breaking into it. Fourth, you're going to want to potentially notify some of the financial institutions of the deceased passing. And fifth, you're going to want to speak with an attorney to determine whether or not probate is or is not going to be necessary. Those are 5 very simple things that need to be taken care of before commencing probate and in consideration as to whether or not probate is actually necessary. So the first item on that list is essentially to deal with the remains of the deceased. The primary reason that you're going to want to do this, and it'll usually be the spouse or the parents or the children or whomever is considered next of kin that is put on point with this, is, well, twofold. First, because you're going to want to pay your respects and go through that mourning period and give an opportunity for the friends and loved ones of the deceased to say goodbye. But secondly, in order to obtain a death certificate, which is a document that's going to be needed regardless of whether or not you do or do not go through probate, you need to coordinate with the medical examiner that has received the body after it's been deceased. You have to coordinate with them and a funeral home or a crematorium to have the funeral home or the crematorium take the body. And the reason that this has to occur, or the reason that this is important to occur, is because the crematorium and or the funeral home is the entity that will ultimately issue, or not issue, but they will request and fill out the forms to Washington's Department of Social Health Services to release the death certificates. So in order to get the death certificates, you will usually have to have the body released from the medical examiner to a funeral home or to a crematorium, who will then obtain them for the family members. So the first step in preparing for probate and considering whether probate needs to occur is to essentially deal with the remains of the deceased. The second item that you should really look into is to try to determine whether or not the deceased did or did not have a will. And if they did have a will, try to locate the original wet ink signed version of that will. And the reason for this should be fairly obvious. If they had a will, it's going to have to be submitted to the court. You're going to probably want an attorney to review it, and it's going to also let you know who that deceased individual wanted to be their personal representative, what assets they had, who they want to receive those assets, etc., etc., etc. You're also going to want to try to find the original wet ink copy of that will, because it makes things a little bit easier when going through the court for purposes of probating that will. If you can't find the original, it's not the end of the world, but if you can find the original, that is what your attorney is going to want you to provide to make it easier for them and for you to have the person that's named in there to be appointed as the personal representative. It's also valuable to determine whether or not there is a will. If you try to find a will and you can't locate one, it usually means that there isn't a will. This is also important because if it turns out the estate needs to be probated, it's important for your attorney to be able to inform the court, we've diligently tried to locate a will, We could not find a will, so therefore we have to proceed with this probate as an intestate estate. An intestate estate essentially means that there is no will, and the estate is going to be probated in accordance with Washington statute. So the second step that's very important to do when determining whether or not you need to commence probate or in preparation for commencing probate is to try to locate the will of the deceased or determine if they did have a will. The third item on the list of things to do, and yes, I was just looking at my notepad real quick there, is to secure the real property of the deceased. And this is something that you want to be careful of not getting too involved in, because technically speaking, only the personal representative, once appointed by the court, is the entity that is required and that is authorized and obligated to secure and marshal assets of the deceased. However, realistically speaking, sometimes it takes a little bit of time for the probate to be commenced and for somebody to be appointed. And during this time period, you don't just want to leave the deceased's house unlocked with windows opened, possibly dogs and cats still living in the home that nobody's able to take care of until somebody's appointed, and mail accumulating on the front doorstep. So realistically speaking, somebody should make sure that the cats and dogs that were the deceased individuals aren't just locked in the house for the next 4 weeks while we're waiting for probate. Somebody's going to want to make sure that all the doors and windows are locked, and somebody's going to want to make sure that there's not a ton of mail just accumulating on the front doorstep, letting burglars and thieves know that this house is currently vacant. This person, best option is obviously if there's a surviving spouse, because that person will not only be able to make sure these things occur, but will still also likely be living there and will be able to keep an eye on the house and make sure that it's kept secure. But if there is no surviving spouse, or if the surviving spouse for whatever reason doesn't live in that real property, then I would suggest a family member, parent or child, potentially brothers or sisters, going by the property and making sure that everything is secure and locked and that nobody's going to break in. Again, you have to be very sensitive with this. You can't access the property and start taking assets out and distributing assets as though you're the personal representative, but it is reasonable for somebody to go to the property, make sure all the doors and windows are locked, make sure that mail is not accumulating on the doorstep, make sure that dogs and cats aren't starving inside the house and stuff like that. So that is my third step in preparing for probate. Make sure that the real property is secure and that nothing's going to go wrong with cats and dogs in the house or somebody breaking in or something along those lines. The next item on the list of things that I would suggest doing is something that you don't necessarily have to do but might be worth pursuing. And this is especially true if you are a surviving spouse or potentially children of the deceased, and that is to notify financial institutions that the deceased person has passed away and provide them a death certificate. The reason for this is threefold. First and foremost, potentially the deceased person had some of his financial assets. Maybe he had them listed as joint rights of survivorship or pay on death beneficiary accounts, which means that upon notifying the institution of the passing and providing the death certificate, those assets will be automatically released to whomever is named on that account. And this can be extraordinarily helpful in certain circumstances, such as when you have a surviving spouse that might need to have access to funds. It's helpful for them if the deceased had a pay on death account set up or a joint right of survivorship set up on the accounts, so that way that surviving spouse doesn't have to wait a few weeks for the probate to be opened and those funds to be released for her to be able to utilize. So it is worthwhile to tell the banks for that purpose to see if there's any pay on death or right of survivorship accounts that might be transferred automatically. Secondly, it's a good idea to do this because the banks, being aware that the deceased individual has passed away, will know to keep an eye on that account. If they see substantial transfers coming out of an account that seem, a little weird for a person that's passed away to be doing, they will likely put a stop hold on it, or they will do something to make sure that those accounts are not going to be transacted on now that they know that the individual's passed away. So it's important to do that as well. Thirdly, and this is one that I think is very important, it's a good idea to let financial institutions know that the individual's passed away, especially if that person had a mortgage. It's a smart idea to do this because if you notify the financial institution, the lender, that the individual's passed away and that there's a mortgage, you're giving them notice that, hey, there might be a couple of mortgage payments that are going to be missed. We're in the process of opening a probate to deal with the mortgage and to address it, but for now it's going to take a few weeks. Can you please give us a little bit of a breathing room or a furlough for purposes of getting the probate up and running? And generally speaking, the banks, once they're notified that the individual has passed away, they'll put a note in their system, and you'll have a few months before they'll start, pursuing foreclosure or some other kind of craziness if they see a couple of mortgage payments missing. Don't get me wrong, the banks are still going to want to collect their mortgage, but they just will give you a few months to essentially get back on track or to have the estate start addressing the mortgage. So that's some good, that's the fourth thing on the list of things that I would suggest doing in preparation for probate. Again, it doesn't have to be done. Technically speaking, if nobody does it, the personal representative, once appointed, will start addressing the financial institutions and notifying them of all that to let them know that the individual's passed away and to, access the accounts or to notify the mortgage lenders. But the sooner you can do it in some of those circumstances, the better, because it'll start to kind of get things lined up the correct way, especially for the surviving spouse. If she's needing to access funds and there's a pay on death, there a right of survivorship account set up, it's very, very helpful for her. Last but not least, the most important thing in determining whether or not a probate is necessary and in preparing for probate, I highly, highly advise that you consider speaking with an attorney. At least speak with one about the probate process and as to whether or not one might or might not be necessary. It is invaluable to just have an attorney hear what is going on with the estate and to potentially take a look at a will if there is one, or to hear what the assets of the estate are, because they can tell you very quickly whether or not this is an estate that will need a probate in order to transfer and access the assets of the deceased, or whether you might not need to have a probate, that maybe things are already set up for transferring the assets to the individuals that won't require it. But if you don't speak with an attorney, you won't know. Additionally, assuming you speak with an attorney and it turns out that a probate is necessary, you absolutely are going to want to hire an attorney to assist with the probate process. Probate is a legal mechanism. It requires appearance in court, and it requires you to file pleadings with the court and to keep the court up to date as to what is going on and to follow statutory guidelines and rules of procedure. It is not something that I would ever wish upon a layperson that's not used to it. I'm not going to lie, there are plenty of people that have not hired an attorney and have been able to commence the probates and have been able to somewhat work their way through it. However, 9 times out of 10, whenever I have a potential client that shows up that has commenced the probate themselves and is now in a sticky position, I will take a look at it and I will see that there is multiple mistakes. And all that means is that I'm going to have to correct them, and it's going to take me twice as long because now I have to look at everything they've done. I have to file corrective pleadings or motions or petitions with the court and correct it. And 9 times out of 10, it's better to just start with the attorney. Additionally, and I cannot emphasize this enough, if you are appointed as a personal representative, you need to have an attorney, because what you are being appointed to is a fiduciary position where you have obligations to the beneficiaries, the estate, and to the court that you can be held liable for if you do incorrectly. So your attorney will keep you within the guidelines and make sure that you are adhering to those fiduciary obligations. Finally, what most people do that do not hire an attorney that I see on the regular basis is they can open the probate, they will even get through transferring the assets of the probate, but they will usually completely fail and forget to close the probate and get themselves discharged as the personal representatives. You want an attorney to assist you with this, because otherwise you have maintained the probate in an open status. It is maintained open to liability. And if the estate is maintained open to liability and you're the personal representative, you're maintained open to liability. So again, there are multiple reasons to hire and have an attorney, to at least speak with an attorney in preparing for the probate process or determining if one is necessary. So I would highly, highly, highly recommend speaking with an attorney and retaining an attorney if probate is necessary. So that is it. That is the 5 things that I am suggesting be done in preparation for a probate, or in determining whether or not a probate is going to be necessary. I hope that you found this useful, and if you did, and you do have some need for a estate planning or a probate administration or an estate litigation attorney in Washington, please feel free to give us a phone call here at Nowakowski Legal, PLLC. We would be happy to give you a free consultation and hear your case and let you know if we can help you. Other than that, thank you very much for taking the time to listen to my video, and I hope you have a great rest of your day.